Hi everyone, and welcome to a real estate educational series with Anna Stepchenko. I'm a real estate professional from Miami, Florida, and decided to create this series with two main purposes: educating and informing my audience on basic yet very essential real estate topics. Hello everyone, and welcome to the third episode of the real estate series with Anna Stepchenko. And in today's topic, we will be discussing a very broad subject called Landlord and Tenant Act. To obtain more information on such act, I came to the law offices of Andrew Tarr, a renowned real estate attorney with over 26 years of experience, who graduated the University of Miami and whose practice involves anything that has to do with real estate. Hi Andrew, how are you?
I'm doing well, Anna. How are you?
I'm doing great, and once again, thank you so much for doing this interview with us today.
My pleasure. Educated public is the best kind of public.
Absolutely. So Landlord and Tenant Act, it's a really big subject, and when signing the lease, there is this additional 11-page act that landlords and tenants initial, and we all know how important it is. And everything is important. However, what bullet points from that act would you point out right now to our audience to pay extra attention to next time they sign the lease, either on the landlord's or tenant's side?
Well, it's an interesting fact that it is actually the entire law is attached to every lease that's entered into between a landlord and a tenant. So you could always read it, and it's interesting. There are some things that you might find surprising and some things that just make common sense. Problems that arise mostly where the Landlord-Tenant Act comes into play would relate to security deposits, when a tenant vacates the property, or problems that the tenant might have when they're actually occupying and residing in the property and the landlord refuses to fix certain problems. So there's different situations that could come up during the course of a tenancy, and all of them, hopefully all of them, are covered in the Landlord-Tenant Act.
So my first question at this point would be security deposit. What steps should tenants take in order to maximize the chances of being refunded the entire deposit back?
Great question. And I tell clients all the time when they come to me before a lease is entered into, the first thing that you should do is take pictures, take video of the property before you move in. If there are any problems that you can see, identify it and document it. That's the most important thing that you can do, because I guarantee you when you leave, the landlord is going to think that you did it. If they know that you did it or they didn't know that you did it, really doesn't matter. It's the accusation that you want to avoid. And if you could take a picture of it when, show the landlord a picture before you took occupancy, that'll go a long way towards proving that this is not my fault and I'm not going to pay for it.
Absolutely. And based on that, I have a second question. Is there any time frame or any rescission period, so to speak, for the tenant after moving in to address any issues with the property? Because what happens on many occasions, even in my practice, we do the walkthrough inspection, we exchange money and keys, and a lot of defects are latent, so they are not visible right away. And then, let's say a few days after moving in or a week after moving in, the tenant calls me or texts me and addresses particular issues. So is there an actual time frame to address them?
There's no waiting period, or there's no time frame within which the tenant can cancel the contract. I mean, once they've done it and they paid their money, in particular once they've moved in, they're in. So the best thing that a tenant can do, and an agent like yourself who's representing that tenant, is to make sure that when and if a problem arises, we know who's going to pay for it. So obviously, if I'm representing the tenant, I want the landlord to be responsible for most items that have to be resolved. And in fact, the contract to lease, the lease itself, has a part of it where you can check off who's responsible for this, who's responsible for that. And obviously, if you're the tenant, you want their landlord to be responsible for everything. If you're the landlord, you want to put most of that responsibility on the tenant. So my answer is going to be who's coming to me. It's going to depend on who's coming to me for that advice. But you, if you're representing the tenant, definitely you want to make sure that your tenant is covered for any potential problems.
Absolutely. And now I would like to talk a little bit about landlords. In the event there are issues with the property and landlord decided to withhold a certain amount of money from a security deposit, what is the correct step for the landlord to proceed?
Okay, good question. And there's a lot of sub questions that might come up that I should probably just try to touch on. First of all, how's the deposit held? The landlord has got a responsibility to hold the deposit in a non-commingled account. That means he can't put it in with his own money. And it should actually raise interest for the tenant over the period of a year. There are ways around that. We're not going to get into that here, but for the most part, that's an important consideration. So once a tenant vacates the property, the landlord has an opportunity to inspect the premises and to see what kind of problems there might be. Now, the same advice that I gave the tenant when they took occupancy is going to go when they leave. Take a video, take pictures of what the property looks like when you're leaving now, and you can compare. So if the landlord comes back and, as he's supposed to do, sends you a notice within 30 days of your vacating the property that he intends to make a claim on your security deposit, the landlord has an obligation by Florida statutes, the ones that are attached to the lease, to detail what those problems are, detail exactly what he is alleging that the tenant, what damages he's alleging the tenant caused. And if the tenant has that evidence that he can refute that, that's obviously going to go a long way towards helping them. Now, just let me take it one step further. So if the landlord wants to make a claim on the deposit, he has 30 days to do so, and he's got to send a very specific notice that's outlined in the law. When I say outlined in the law, I mean literally the words are in the law, and you have to use those words.
You just need to basically copy and paste.
Exactly. Just the only thing that you're adding to it is what the actual problems are, what the damages are, and how much it costs to replace that. If the landlord's not going to make a claim, then he has 15 days to return the money in full to the tenant. So let's just take it a step further and assume that the landlord is making a claim or trying to. He sends a notice to the tenant by certified mail within 30 days, and then the tenant gets it. And they come to me or they come to you. What do we do now? Well, now the tenant has 15 days to refute that letter, basically to tell the landlord, no, I'm not going to pay for this because I didn't cause these damages. So the tenant must send a letter that he objects to the landlord withholding money from the security deposit. And after that is when it gets tricky. Because somebody, if they can't get together and resolve this, somebody's going to go and sue somebody else. And whether that's the tenant or whether that's the landlord, that kind of is up in the air, but one of them would have to do that.
Can it be done by email, the communication, or certified mail?
Let me just say it like this. If there was the proper notice sent by email, I wouldn't hang my hat on it if I was the tenant to say that the landlord didn't serve me properly. And the reason being is that a judge, who's ultimately going to be the one deciding this issue, is or may not think that that's important, may not think that that's a material thing, because you're going to be able to prove that the tenant got it. And that's really what the idea is. And when this law was written, they didn't really take into consideration email. So certified mail was the best way that we can ensure that a notice was sent and received.
And well, basically you can do both nowadays.
I always recommend do it by certified mail, because then there's no question. If I come to a situation where somebody was actually served by email, I'm probably going to look at the totality and err on the side of caution and proceed accordingly.
Thank you, Andrew. And last question would be about uninhabitable conditions of the property. As we know, there is mold, there are termites, there are so many other disasters that tenants come across on many occasions, and they have a problem with the landlord fixing these issues. Can you please provide us a little bit more information how the tenant can protect himself from these issues arising along the way?
Sure. And there's another notice that has to be provided to the landlord if the problem is so egregious that the tenant really finds the property to be uninhabitable. And I want to just caution you that it's not a situation where you can complain about anything. It really has to be substantially interfering with your ability to use and enjoy the property. If the washing machine is too loud, you can't really complain about it. You can try to get your landlord to fix it, but it's not going to be a reason enough to go with the notice that I'm about to explain to you. So the notice is this. It's a 7-day notice. It says, hey, landlord, I'm having a problem with, for example, termites or mold or something that's gross and doesn't, really permit a tenant to be there in a sanitary condition.
Jeopardizes your health.
Sure, mold is not healthy. And if that's a situation, you've got to send the landlord a notice, and that notice is going to say, I'm not going to pay you rent until you fix this, or I'm just going to leave. I can vacate.
And this is actually law.
This is the law. And if the landlord does not address the tenant's concerns within 7 days, then he can leave. Now, that's not to say that the tenant must stay there during that 7-day period and, be in a situation that's potentially toxic to their health. I'm not suggesting that. If it's something that's unhealthy, then you leave. If you don't have anywhere else to go, unfortunately, that's not a good reason to stay there. You have to consider your health first. So if the tenant is in a situation where he finds the property uninhabitable, then he sends this notice to the landlord. If the landlord continues to ignore it, then the tenant can leave, and you oftentimes will eventually wind up in court because the landlord's going to say that the tenant broke the lease, the tenant's going to say that the landlord broke the lease because he didn't keep it in a sanitary condition, or he concealed a condition that was unsanitary. And I've seen this. I've seen a landlord cover up mold or what appeared to be mold or really disgusting conditions, covered it up with floorboards, just made it look like it wasn't there. But when you lift the floorboards, it revealed a completely different scenario than the tenant really envisioned when they signed the lease.
So that's really good news, because on many occasions tenants get really scared of doing something wrong. However, the law is also on their side, and there are certain provisions that protect them. So thank you, Andrew, for addressing them.
Yeah. One thing about the law being on their side, I do agree with that. This is an informal thing, but baseball, we have something called the tie goes to the runner. I would say in a residential tenancy, the tie, if there's a tie, goes to the tenant. And the reason would be, and this is not like black and white, okay? Any judge can make up their own mind. But the reason is that a judge might look at it and think that the landlord is in more of a position business-wise to know what's going on. And the tenants are just like, I just want a place to live that's going to be safe for me and my family. And the landlord really shouldn't be doing things that they shouldn't be doing. They should make things as comfortable as possible for their tenants, because they're being paid, and paid usually well for it, especially here in South Florida.
Absolutely, Andrew. And in the end of the video, could you please point out the major key points to landlords, tenants, realtors, to make sure that the next executed lease agreement will be successful and peaceful?
In addition to what I was telling you about taking the pictures, the before and after videos and pictures, you should make sure that your tenant, if you're representing the tenant, remember, I'm gonna give you advice depending on who I'm representing.
Absolutely.
But make sure your client is going to get the better part of the options in the contract as far as who's responsible for what.
Okay, Andrew, thank you so much. It was very knowledgeable and informative.
Pleasure.
Thank you so much for watching the real estate series with Anna Stepchenko, and we will see you soon. Bye.
If you ever find yourself in a situation where you feel like you're being taken advantage of, whether you're a landlord or a tenant, please feel free to call me, give me your situation, tell me your facts, and I'm happy to give you a free consultation. And if I can help you, I promise you that I will.